Hello everyone and welcome to Creative Connections. My name is Kevin and today we are partnering with Arts Law to learn about contract management during times of COVID-19. Before I start, I would like to warmly acknowledge the traditional owners of countries throughout Australia, including where you are today. I pay my deep respect to elders past, present and the future. Currently on screen is a maroon PowerPoint slide deck with some text, some video boxes of our guest speaker and Auslan interpreters. I, the host, am a fair-skinned man with brown hair and wearing a grey shirt. This webinar series has been developed to support you during this time of intense change. They're bite-sized and will be delivered regularly throughout the coming months. So far, we've had some amazing speakers join us and we look forward to continuing to learn to adapt our leadership, our digital capability and our practices. Please share this opportunity with others if you think they will benefit them. These sessions are for you. Laura in our team will briefly recap a few housekeeping items before we introduce you to our speaker, Suzanne. Thanks, Laura.
Thanks, Kevin. Hello, everyone. Thanks for joining us for today's session. My name is Laura. I am a woman in my mid-30s. I have dark brown hair, blue eyes, and today I'm wearing a black shirt. I'm coming to you this morning from Gadigal land. I'm just going to talk through some of the features of today's webinar. Firstly, closed captioning is available. If you can't see it on your screen now, you can press the CC button at the bottom of the Zoom window, and you can also open out the full transcript if you prefer. We also will be running a chat throughout today's session, and we encourage and invite you to share any ideas, resources or responses with each other throughout the session. Due to Zoom security settings, you aren't able to hyperlink or copy and paste out of the chat window. You can find the chat at the bottom of the screen. We'll also be running a Q&A session with Suzanne at the end of today's webinar, and Ian will be looking after this. So if you have any questions, add it to the Q&A box again at the bottom of the screen. We're going to do our best to get back to everybody, but if we don't get back to you, you can email us and we can respond to you directly. If things aren't working, if you're having issues, technical troubles, you can raise your hand again at the bottom of the screen. And Francis will be in touch with you and try and sort it out. We are also recording this session. It will be published on our website in the next couple of days, so you can share it with anyone who you think might be interested. But I think that's pretty much the logistics. I just want to say thanks so much, Suzanne, for hosting this session, and have a good weekend, everyone.
Thank you, Laura. I would also like to just briefly add that today's discussion is around the topic of the webinar. And if you have any other urgent inquiries that is unrelated to today, please get in touch with us and we can direct you to the right information or person here at Council. Also, as Suzanne will most probably highlight, that we will not be able to provide any specific advice on specific cases today, but hope that you will learn about general legal concepts and also know where to find help if you need to after this webinar. Also, if you have an Australia Council a grant and your project has been impacted like many by COVID-19, the key advice is that you contact the grants officer that is assigned to your funding. And we acknowledge that each person and organisation situation is going to be different, and the team is ready to support you to find the right solution for you. So if you don't know who your grant officer is, you can access this information through our grants online system, which is called Flux, you might know. And if you still can't find it, please contact our inquiry team. There are several telephone numbers and email addresses, but the two that I'll quickly highlight is our main telephone number, which is 02 9215 9000. And via email at inquiries@australiacouncil.gov.au. Currently on screen is a PowerPoint slide with to introduce our guest speaker. There's text and an image of a woman with light hair shot in portrait format. The Australia Council partnered with Arts Law Centre of Australia to run today's session. We thank them for their support and engaging in our series. Suzanne Derry is the Director of National Partnerships and Programs and Senior Solicitor at Arts Law. And Suzanne has been at Arts Law Centre for the past 10 years, and it's really great having her here with us today. And I know that Suzanne has just baked some hot bread as we were coming online. So let's ask her about that. But Suzanne will explore a range of legal topics today to raise our awareness and our understanding of potential impacts of this pandemic on contracts, and also to make sure that you feel that you know where to go and seek help. Suzanne, thank you so much for being with us today and sharing your thoughts. I will hand over to you, and I believe that you also have some slides to share. Welcome, Suzanne.
Thank you so much, Kevin, and thank you everybody for joining this webinar. I hope that you'll get everything that you hope to from it. I'm just bringing up my slides now, and thank you for the introduction. Before I begin, I'll just explain that I am a fair-skinned woman with blonde hair in my mid-30s. I would also like to echo Kevin's acknowledgement of the various countries upon which we are all sitting today, and to really acknowledge the elders, past, present, and the emerging future leaders of our amazingly rich Indigenous cultures of Australia. As Kevin said, today is going to unpack some of the challenging constructs around contracts in light of the pandemic in which we have all been landed. And I will be talking through some of the aspects of how Arts Law can help, but if you can just jot down or make a note of what our web address is, there is a lot of information about how our organisation can assist. In essence, we are Australia's only community legal centre that is national and designed to assist artists and arts organisations. And so, as you can imagine, we are getting lots and lots of questions from artists and from organisations about the impacts of COVID-19 on their various projects. We cannot do what we do without the funding that we receive and the people who support our organisations. So today I'm going to chat through a few things, starting with a case study which I thought would contextualise this for us. I'm then going to talk through some of the questions which you as a creative or somebody within a creative organisation should be asking now, and also some of the renegotiation tips that you might find handy. On the slide in front of you is a slide with some text and a sort of circular shape on it. It's a black slide with white text on it. We'll talk through each of these things in turn. And of course, if there's anything that raises questions for you, feel free to use that chat box and we'll do our best to address them at the end. This case study slide is a blue slide with white text on it. And this is a case study of an organisation that many of you may have heard of. It's a performing arts organisation that is based in Australia but tours internationally. The organisation is called Circa. Now, talking to one of their senior producers just recently, fantastically motivated arts worker Danielle Kelly, she told me the following: "We are an international company who average touring to around 15 countries a year, as well as domestic Australian touring, and COVID-19 has had a very large impact for us. We were in the middle of a tour in France with forward dates for that particular company booked in Belgium and Switzerland, and had to cancel many shows and evacuate the company out with a day's notice." So you can imagine that from a planning and organisational perspective, the upheaval for this organisation, much as you may have experienced in your own arts practice, has been immense. But the other side of the fallout of all of this is, of course, the contractual issues that flow. from being in a situation like this. And they include things like having to delay or cancel or reconfigure what those agreements say about the performances. And you're having to do that with venues and presenters who are overseas. Now, that creates its own contractual complexity because you're working with jurisdictions other than Australia. And in contracts world, that can make things infinitely more complex. The contracts with the performers, of course, in a scenario like this are also then disrupted because it means that you are asking people who've already committed to being in a certain place, to do a certain job, to leave that place and come back to Australia and not do the job that they've committed to doing in their contract. You're also then in a situation like this having to renegotiate multiple agreements without the certainty of what's actually going to happen. And what we're hearing from artists and organisations is that this is one of the really, really difficult things about dealing with the contractual complexities of COVID-19. And that is that we don't have certainty in terms of when it's going to end, when all of the fallout of this is actually going to stop. And so knowing how you can actually then craft a contract which is really tightly bound around dates is very challenging. So we're going to talk a bit more about that. Hopefully that helps people to have a bit of context as to how some of this is all playing out within the contractual realm. And I have no doubt that for those of you playing along at home, there are all sorts of concerns within your own arts practice and your own arts contracts that you might be thinking about as relevant to you. In terms of what's happened here in this particular case study, I'm told by Danielle that this is a work in progress really for them, trying to renegotiate a lot of these contracts. In some cases, the negotiations are on hold, where they're in countries which have been so significantly impacted by COVID-19 that their ability to respond to the contractual negotiation process has also been delayed. In other cases, they've had to renegotiate their contracts with performers, they've had to renegotiate their contracts with venues, and in some cases they've had to look at termination as well. So look, it's a real smorgasbord and a very, very challenging contractual landscape for people at the moment. What I'd like to do on this slide, which is a black slide with a picture of a key on it and some white text, is to talk you through some of the key questions that you should be thinking about with your arts contracts right now. There's a lot going on for everybody. There's all sorts of concerns for the creative community, including drastic and significant losses of income, incapability of performances and exhibitions, and the contractual issues may seem very, very distantly related to what you're doing. But I think that if you can get onto this earlier rather than later, you've got a much better chance of a solution that is actually going to work for you. So let's talk through some of the key questions that you need to be thinking about now. The first question for you is there a contract? And we're going to chat through that. In some cases, that will be obvious because you'll actually have something in writing and that you've signed, you know, whether it was last year or 6 months ago or 3 years ago. But in other cases, you might be left wondering, hang on, I don't really have a signed agreement. I don't actually know if I've got a contract. The next question is, what does that contract say? Now, for many creatives and organisations, you may have reviewed the terms of that contract at the time that you signed it a few years ago. You're now in the position, though, of needing to look at that contract with fresh eyes because of this intervening event of the pandemic. Your next question is, are there clauses in that agreement about what happens when you don't or can't deliver on the contract's promises? So again, we're having to revisit the contract that you may have signed, not ever really thinking that anything like this could actually intervene in your project. Our fourth question is, can you negotiate something new? And the fifth question is, how do you actually formalize that new arrangement that you come up with? Now, before we delve into each of those areas, what I would like to share is that our experience up until now at the Arts Law Centre has generally been that both of the parties to the contract, both of the people in that agreement, both of the businesses in that agreement, are on the same page in terms of the need to communicate and try to come up with something fair. And I think that that is a real, really important aspect of the arts at the moment, is the communality of experience and impact of the pandemic. In other industries and for other lawyers, like lawyers who work in insurance law, for example, that has not been what I have been hearing. And there are, of course, much more adversarial and commercially aggressive approaches to dealing with COVID-19. But fortunately, our experience at the moment, as I say, in the arts has been that open communication is key, and that generally people are working very hard together to try and come up with solutions to what has been a very unexpected turn of events. So my next slide is white with some blue and black text on it. Our first question is there a contract? As I said, if you've got something in writing, it might be obvious to you that there's an agreement. But if you don't have anything in writing, your question might be, well, do I actually even have a contract? So what is a contract? A contract is an exchange of promises or a legally enforceable agreement between two or more parties. Now, the word party is not what we're all hoping it means at this current point in our isolation. Parties in an agreement are really the people or businesses or agencies that enter into that agreement together. The contract will also contain what's called terms, and those are sort of like different chapters in the story of your arrangement with that other party. And then a contract is also going to talk about what the various rights and obligations of each of those parties are. So in order to actually establish that we've got a binding contract, there are really four fundamental building blocks. And they are that you've got an offer, that the offer's been accepted, that there's been some consideration, which is usually the payment of money or the offer to pay money, and that there has also been an intention by the parties to have a legally binding relationship as a consequence of having that agreement. We've got a fantastically detailed information sheet on our website about contracts and their building blocks. So I'm not going to go into much more detail than that because there's a lot more content that we need to cover. On this slide, we've got the picture of a woman's mouth and the question in blue font, what about verbal agreements? Now, we often get asked this question because it is frequently our experience at the Arts Law Centre that people enter into agreements without having a written document. Now, agreements can be verbal, and you can have a binding contract between two parties that is made verbally. One of the obvious challenges at the moment is that when you've got a verbal agreement, every indicator in my experience is that there is very little detail in that verbal agreement about what happens when things go wrong. And so at the moment, when things have gone quite drastically wrong in a number of contracts, one of the challenges with relying on a verbal agreement is that those verbal agreements may lack the sort of clarity that you need to guide you through what the story of your relationship with that other party is at this point in time. So verbal contracts can be binding as long as they satisfy those fundamental building blocks that we talked about in the last slide. But as I said, they can be very vague as to what the terms actually are, and often verbal contracts don't properly deal with what happens when there's a dispute. Now, there's every possibility that somebody joining us today has got the question in their minds, what happens with emails or messages on Facebook? What about those? Are they contracts? Now, those can constitute evidence of an agreement. And what we always say at Arts Law is it's better to have something in writing than nothing at all. But it's even better to have something that is detailed, that sets out clearly what the various terms of your agreement with somebody else are. Our next slide, which is white with a blue heading and black text underneath it in bullet points, looks at the issue of what happens when there is a written contract. So if we've moved on from the prospect of it being a verbal or non-written agreement, what about when there's a written contract? What does that contract say about your inability to deliver or perform on the terms of that agreement? Or perhaps the other party's inability to deliver on the terms of that agreement? So one of the first questions that we ask when we look at that type of contract is, okay, on the basis that you are not able to do the thing that you said you would do, are you technically in breach of this contract? Now, being in breach of an agreement means that you are not doing the thing that you said you would do under that agreement. Does the agreement say that you need to do this thing and you now cannot do it because of COVID-19? We also need to look in that contract as to whether or not there's what's called a force majeure clause. And we're going to talk a bit more about that because many of you may have heard about force majeure clauses and have some questions about what they actually mean. Also needing to check in that agreement what the termination clause looks like, and also what the clause about notice says. Now, we're going to unpack each of these in turn, but just to give you an overview of where we're headed, this slide is sort of designed to just do that. And the last question is, has the contract been frustrated? So we'll talk through each of those now. The first question is there a force majeure clause in your contract? Now, back when I was studying contract law, one of the things that we did was we looked at this concept of force majeure in Australia. And it was all done very dryly, which much of contract law often is, unfortunately. But I never in a million years thought that force majeure would become the sort of the catchwords of the day in the world of contract. And because of this pandemic, they really have. So what is a force majeure? Look, in its French language sense, a force majeure is a superior or overriding force. In contract law, it's a bit more than that. A force majeure in contract is an intervening force, which means that it becomes impossible or very difficult for one or both of the parties in that agreement to deliver on their promises in that contract. So it's very much going to depend on what your contract actually says. What the words of your agreement say are a force majeure. Because interestingly, one of the things that we are finding is that only a few of the agreements that we've sort of looked at force majeure on really actually anticipate something like a pandemic as being a force majeure. And that's because, you know, pandemics are so rare that contract lawyers and commercial practice is generally that pandemics aren't the first thing that you might consider would intervene in the performance of a contract. But more frequently, there is an inclusion in a force majeure clause which describes things like floods or fires as being acts of God. And more regularly, we are also seeing clauses that include acts of government as well. And that's really relevant to the arts sector because at the moment, government policy in and of itself creates legal impositions to artists and creatives being able to perform their obligations. So without any judgment or political statement around that at all, it is simply a fact that if the government says, okay, we're now shutting all venues, it's no longer lawful for people to convene in groups greater than 2, it is impossible for you as a performing artist, for example, or as an exhibiting artist, to hold that exhibition in an open space, to perform that work in a venue. And so what happens is that act of government may actually create a force majeure in your contract for the performance of that work. So it's important to look at this clause and to read it, because what it might do is to talk about your ability to either suspend the agreement, that is, to hold it in space and time, and to just pause until the event of the pandemic has passed, or the contract may actually say that in the instance of a force majeure, the agreement itself actually is extinguished. The obligations in the agreement are extinguished. The other part of an agreement that you should be looking at right now is also that clause around termination. Now, as I said, our experience in the arts at the moment is people don't want to terminate their agreements. Generally, they want to either suspend or postpone or delay the performance of those agreements. But in some instances, termination is going to be the only viable option for one or both of those parties because of their particular circumstances and the way in which they've been impacted by the pandemic. So your termination clause in any written contract that you have signed will include information about how that termination comes into effect and when you can terminate. What we're always saying at Arts Law is, before you sign a contract, and indeed, if things do go wrong after you've signed the contract, be careful to read that termination clause well, because it often includes information about how equal the rights between the two parties actually are when it comes to termination. And in some of the very unfair contracts that we see for artists, they sometimes say things like, you know, the stronger bargaining party position can terminate the agreement without any notice to the artist, and the artist will bear all the costs. But in the more fair agreements for artists, what we are seeing is more even termination rights, which talk about the fact that the artist is allowed to terminate and the other party is also allowed to terminate, but that there are certain provisions around how that can happen. Now, the very, very close connection to both termination and force majeure is that of notice. On this slide, which is white with blue text at the top and black text in bullet points, we explain a bit more about notice. Now, what is notice? Notice in a contract is the process of formally telling one of the parties to that agreement something is going to happen, or something is not going to happen, or that you intend to do something or not do something. So a notice is a formal communication that has, in the train of how the agreement operates, an impact down the track. So one of the things that it's really important to understand if you're looking at operating that, at pulling the levers of that force majeure contract or pulling the levers of termination in your agreement, is to understand how you actually give notice in that contract. The agreement that you have should specify how that notice should be given, because different contracts talk about different ways of giving notice. And it's very important that you comply with those notice provisions if you actually then want to take the next step of working through your termination clause or working through that force majeure clause. Next, we're going to talk a bit about frustration. Now, this is not something that you will directly find a clause about in your contracts, because it is one of our common law doctrines in Australia. Now, we all have, you know, whether we're parents at home with children, whether we are stuck at home missing our friends and family, whether we have had numerous events cancelled, we've all had very active experiences with frustration in the last couple of weeks, but this is not that kind of frustration. Frustration at law, at common law, is the explanation of what happens, or is the outcome of what happens when the situation is such that a contractual obligation has, without the default of either party, become incapable of being performed. And there's a famous and quite old case called Codelfa versus State Rail, where the court unpacked these key elements of frustration. Now, I know, and you know, that the cost of going to court and saying, has this contract been frustrated? Let's look at its key terms. Has it become so impossible to actually perform the terms of the agreement? Is really prohibitive for most artists and organizations. And if you want to find out more about whether or not frustration is sort of something that you should be considering in your agreements, of course, you can get in contact with Arts Law and we can provide you with some advice. Largely, the thing that most people in this position of having an intervening pandemic that's now interfered with your ability to deliver on the obligations in your contract want to know is, can you negotiate something new? And if you can, what does contract law sort of say about how to do that? So on this slide, which is white with a blue heading and some black text in bullet point and a big question mark in blue, I explain that negotiating something new in a contract is generally called a variation to that agreement. And what you might be doing is you might be responding to a proposal by the other party to vary your contract, or you might be making a suggestion about how the agreement can be varied. Now, your contract, if you have a detailed contract in writing, will probably talk about variation and about how to vary your contracts. Usually, it's the practice of most agreements that any variation to the contract will need to be in writing, and it also needs to be signed by both parties. So this is again where having that conversation with the other party to your agreement and saying, look, this pandemic has substantially impacted on our ability to actually do the thing that we said we were going to do in this agreement, but we want to work with you to vary the contract so that it can either postpone those obligations or suspend them at the moment until we know more, or change the way in which we actually deliver on our obligations in this agreement. Perhaps we're going to deliver our obligations online rather than face-to-face. So think carefully when you are going through that variation or negotiation process, because on this slide, which has got some Scrabble cubes, and it has got the words choose your words in those Scrabble letters, we talk about varying or not varying your agreement. And really importantly, you need to consider whether or not that new contract, that new variation to the agreement, should be talking about dates. Because one of our big challenges with the pandemic is not necessarily having an end date in our minds and in our agreements that we can actually safely commit to at the moment. So you might want to tie your commitments in that agreement to some other event that is not necessarily date-based. That event might be an announcement by our federal government or by the World Health Organization. You should think carefully also about whether the payment under that agreement is impacted. Lots of artists have asked us the question, well, what do I do? I've been paid in advance for something that I now cannot actually perform because of the intervening pandemic, and I want to know what I need to do with that money. What are my rights and obligations? What we're telling people to do is put that money in a bubble at the moment and don't touch it, because until such a time as you have varied your contract with that other person, if that money actually is for the performance of something which now cannot happen, there's a possibility that this contractual negotiation process may mean that that money needs to be applied to a new project for you, to a new performance, to a new way of doing things. So you need to be very careful that the way in which you're treating any advance payments carefully responds to what the wording in that agreement actually is. And if the agreement isn't clear about what you do with advance payments when you can't deliver, please come and get some advice. You also need to think about whether a variation to your agreement is actually going to affect any of the insurance along the line. And of course, this is a big challenge for all artists and creative organizations, which is any agreements that you enter into need to be carefully thought through in the overall audit of other contracts that you may already have entered into. So just briefly, if you need help, if you are thinking, well, I've got this agreement and I really don't know what to do with it, and you are an artist or an arts organization, the best thing for you to do is to start by contacting Arts Law so that we can actually either assist you in reviewing your agreement, and there's more information on our website about how we can do that, or we will be able to refer you if we cannot assist you for whatever reason. We've got information sheets on COVID-19 and some FAQs, and we've also got some information about some of the social security impacts for people who might be on, some of those job seeker payments who are creatives as well. So we can direct you to all of that if you need assistance. We'd like to acknowledge the support of our funders, and as always, a disclaimer at the end, as Kevin said at the beginning, none of this is legal advice for you. It is really all a discussion to try and support you. And please know that Arts Law very much wants to assist the arts as much as we can in this very challenging time. So I think that's the end of my presentation. Kevin, any questions?
Well, Suzanne, thank you so much, firstly, for that information. We'll move on to some questions if you're okay with that. We have a few questions that's come in, and just as a reminder, if you've got a question for Suzanne, just pop it into the Q&A section at the bottom of the screen, and we will see if we can pass it on to Suzanne. So, Suzanne, the first question we've got is related to notice, and it's from Jackie. Thanks, Jackie. Jackie asked, how formal does the notice need to be? An email, a phone call, I presume if that's okay. Does the word notice need to be included in any written communication?
Thanks, Jackie. I think that's a wonderful question, because unfortunately, so often, as is the case in the law, the answer is it depends. Really, your contract will most likely talk about how the notice should be given, what the wording of that notice is, and how formal it should be. Your notice provision in your contract might talk about the fact that it's fine to send an email to somebody else. And the other interesting thing that your notice provision will probably do is it will talk about a deeming of when the notice is actually deemed to have been received. So you might send your notice to the other person or the other business by email, and your contract might say that that is deemed, or it's decided by the agreement that that notice has been received at the time that you get a send receipt, for example, in your email. So if you've got any sort of a lack of clarity in your agreement about how notice should be given, it would be good to get some advice about that, so that you can be as certain as possible that you've given adequate notice.
Great. Another question, if you don't mind.
Sure.
So this one is from an anonymous person, but it's a fairly straightforward question. Does frustration need to be determined by court, or how is this implemented?
Yeah, look, if frustration, in order for it to be sort of a common law determination that the contract had been frustrated, yes, a court would make that decision. But there is absolutely nothing to stop two parties to an agreement coming together and saying, together as a matter of mutual communication around the impact of what's happened, look, it's just impossible for us to actually do the things that we all thought we were going to be able to do. 10 months ago, 3 months ago. And so as a consequence, what we all want to do together is actually to end this contract. The tricky thing with the court making a determination of frustration having occurred is not only the cost and time of making an application like that, but also that the common law doctrine of frustration basically says that the loss lies where it falls. Now, what that means is that if a court makes a decision that a contract has been frustrated, the various costs and liabilities of each of the parties to that contract are actually weathered by the party that's already borne that cost. So if you, for example, are an artist that's already spent lots of money on doing something that you thought was going to be possible to happen, but now isn't because of COVID-19, an order of frustration would probably be quite unhelpful to you, because it would mean that you would directly bear the loss of that decision. You'd directly bear the loss of any costs you'd already borne. The far better outcome for artists and for organisations that have borne costs is actually to negotiate with the other side how those costs are going to be borne consequent to this intervening event of the pandemic. So sorry, that's sort of tangential to the question, but I think it's quite important for people to understand that commencing court proceedings is not only prohibitive in terms of cost and time, but actually the outcome of certain decisions, certain types of decisions, can be pretty detrimental depending on your circumstances.
Great, thank you. The next question potentially might require this person to speak to you specifically, but I'll try and generalize it if you're okay, because I think it's quite an interesting question which a lot of people will most probably thinking about. So the question is from Vanessa. Thanks, Vanessa. And her question in general is about future contracts where things are unclear and uncertain. So when there is a possibility for contracting artists, for instance, for, let's say, a festival in the future, what considerations needs to be given just in general?
Yeah, it's a great question, Vanessa, and it's one that comes up often for our communities that we work with. I think particularly because in the arts, people are often working with the catalyst of ideas for things that have not yet happened, and that becomes particularly difficult when you've got intervening events like a pandemic and you don't know what the fallout's actually going to be of that. I think in terms of future contracts, what you need to be really mindful of is whether or not you've actually got a contract at all. You know, when we're talking about future contracts, we're talking about trying to engage people to do things that may or may not happen, or that we don't actually know in terms of the timing of when those events might happen. And you'll remember from, you know, my building blocks of contract clause, or slide, sorry, that one of the things, and I'll just flick back to it, one of the things that's quite important in the matrix of those 4 blocks fitting together is the notion of certainty. Certainty is kind of the cement, if you like, that holds those bricks together. So unless we have certainty around what's actually being offered, and certainty around what the consideration is, and certainty around what the intentions are of those parties, sometimes that little wall can fall over. So with future contracts, I think if you want them to be binding, and obviously this is very general and I don't know the specifics of your situation and it's not legal advice, but for the benefit of everyone, it's very important when you're negotiating a future event that if you want to actually have people commit to that from a contractual perspective, that you provide certainty and that they agree to those certain terms in order that the contract can bind you all. So our first question, sort of in relation to the scenario that you've put, Vanessa, is there actually a contract in the first place at all? Is there certainty of the terms such that we could establish a binding agreement? And then, of course, the challenge at the moment with the pandemic is, even if we had certainty around those future events, has there now been an intervening event that actually almost makes it impossible for those contractual commitments to proceed. So it's a really interesting question. It's one that we grapple with even external to the pandemic. And again, really important when you're looking at these sorts of engagements to get advice so that you can make things fair for both you and the other person or entity that's entering that agreement.
I think we have time for one final question, if you're okay with that.
Sure.
This question, again, is from an anonymous person, but a good one. The question is, do you have any recommendations of resources or places to go to get really good contract templates that has got all of these relevant clauses that are quite up to date? Or do you have any advice around that?
Yeah, look, that's a fantastic question. The Arts Law Centre, because we are the national organisation that supports artists and organisations, has a massive selection of professionally drafted contract templates. They are for sale on our website for between $60 and $80, which is so much more cost effective and affordable for creatives than going and getting one specifically drafted. The other thing that we can assist with once you've actually had a go at drafting one of those templates up is to review the agreement for you, and there's more information about how that works on our website. But it is, it's a great question because artists are so often wearing the hat of the accountant, wearing the hat of the lawyer, trying to generate their own creative practice and business, and it gets really, really difficult. So if you can take away from that very busy matrix the need to actually go off and get a law degree so that you can, know what to put in your contracts, I think that helps. So definitely have a look at the templates that we've got on our website. I think they are fantastic. There are a number of other peak organisations that have got templates on their websites for artists or for their memberships. But a good place to start is Arts Law. And again, if you're not sure what template applies to you in your practice, that's something that we can actually give you advice about. And if there isn't one that fits perfectly, we can help you to put something together and make you aware of the sorts of things that need to go in that agreement. So start with us, and then we can sort of direct you to what resources you might need.
Suzanne, thank you so much. Just to finally wrap up, is there any final sort of thoughts that you want to leave us with today?
Look, no, I think just for people to know that, we are doing our best to support artists. And if you've got questions or challenges that you're dealing with, even if you're not sure that it's a legal problem as such, but you suspect it is, please get in touch with us. And, if it's something we can assist with, we will definitely endeavour to do that. And if it's something we can't help you with, we can also refer you to the relevant organisation. And just wishing everybody, the best and make sure that you're taking care of yourselves in what is a really, really challenging time, and lean on the organisations that are there to support you. So, and thank you very much, Kevin, for having us along in the Australia Council. I think that this series is fantastic and it offers some real insights for creatives at the moment. So we're very grateful to have been joined in today.
Great. Well, thank you so much. And please keep an eye out, because Suzanne, you're coming back and doing another session in several weeks on copyright. So please check out our website for that. Thank you so much, Suzanne.
Great. Thank you.
Before we go, just a quick reminder that next week our focus is on digital adaptation. First, we will be exploring connections, community, and what audiences want online with Tandy Williams from Pattern Makers. And we will also be joined by Peter Tullen from Remix to cover business models and monetizing digital work. Also, just a reminder that there are, of course, several opportunities currently at the Australia Council. If you're not aware of it, our Resilience Fund includes 3 streams that includes focus on survival, adaptation and creation, and those applications are currently open. But also our team here at the Australia Council has got a program called Future Form that is currently open, and the closing date for this will be extended to June to allow for more people to apply. Future Form is for organizations and groups who are thinking of creating organizations to explore business models and transforming and to think about the innovation around the whole business model. I encourage you to check that out on our website and the other opportunities which you can find at the australiacouncil.gov.au, of course. Thanks for joining us, and we will see you next time.